while we're on the black pill discussion, the system being profoundly corrupt, let's go into Rudy Giuliani, because I don't know if anybody disagrees with this, even those who hate Giuliani. I did get an invitation to have a discussion from someone who sounds like they might be on the Giuliani deserved it bandwagon. I'm not sure yet, and if and when we have this discussion, we'll discuss. But for anybody who doesn't know now, Giuliani had his law license only in New York, but I'm going to ask you some other questions on this, suspended in the interim of a pending complaint that was brought for statements he made before court, public statements in the context of the 2020 election contestation, representation of Donald Trump. AGC, which was the Attorney Grievance Committee, filed a complaint against him, and they moved on an expedited basis because it's such an urgent situation. I don't even know how active his practice is, which is one question, but they moved to have his license suspended urgently, pending the final adjudication on the complaint. And it was granted and confirmed on appeal. And that appeal decision is, I say it with respect to the courts, it's rubbish. It was arguing from a conclusion and not towards one. And the justification in there was boilerplate. I've already drafted this. It didn't matter what the evidence was. We were going to come to this conclusion anyhow. First question first. Do you know the extent of Giuliani's practice in law in the first place at this point in his life?
Almost none of his, to give you an example, other than his one appearance in the federal court in Pennsylvania, prior to that time period, he hadn't appeared in court since 1992. So he's not a very active lawyer, at least on the litigation side that I'm aware of. And I don't think, and to my knowledge, he didn't have any cases pending in court, was no longer representing either the campaign or the president. I mean, those matters had already been wrapped up and resolved. And so there was simply no, which will go to one of the most problematic aspects of this ruling, to my knowledge, his legal practice has been extremely limited for a long time.
I guess second question, does this go any higher? Is this worth an appeal to a higher level, or is this precedent going to stand as the new standard for suspending a lawyer's license pending an ethics complaint?
My understanding is he's going to continue to contest it because this was an interim ruling, so there's always a final one later, and that he's going to contest it in the interim, and that may even bring a federal civil rights claim as well. Dershowitz has encouraged him to do so, and so and I hope he will contest it, because the greatest import and impact of this case is not about Giuliani. Giuliani doesn't care too much about court of public opinion. He'll fight this to a certain degree, but he's at where he's at age-wise, and his practice is not, as we've noted, very active. He doesn't need his law license for much. This is about setting an example through Giuliani and setting a precedent, and the precedent is very perilous at multiple levels. First, this reflects the broader problem of licensure in general. I don't agree with the idea of licensing lawyers. All it does is provide an excuse to artificially inflate payments to lawyers by creating fake monopolies that are unjustified and unwarranted in the first place. So that's problem number one. My view is, have truth in advertising. And so tell people whether you have this background or that background, this approval or that approval, but let the people decide who's going to advocate for them in court, not the courts. Problem number two is our entire licensure system is corrupt. And the reason why it's corrupt is it completely ignores the entire point of balances and checks and balances in our system of government. Who decides who licenses lawyers in America? Judges. Who decides whether those lawyers face executive enforcement action? Judges. Then who gets to adjudicate whether or not their own rules and their own enforcement procedures? Judges. And who, by the way, would be better equipped to expose judicial corruption anywhere in America than lawyers? But what lawyer is going to have the motivation to do that? I'll just give one example. I was a young lawyer in Southeast Tennessee, had a case that in a public interest law firm that the head of the public interest law firm was doing. It was a case, it was a horrific case. A young kid who, would describe in detail how his father beat him and described how his father tried to get him to beat his younger sister. And yet the judge came back and ordered unsupervised visitation to force the kid to be in his custody, even though he begged the judge not to have that happen. And I was enraged when I found out about the verdict. And the lawyer explained to me, he goes, Robert, the judge has a sleeping disorder. He has a health disorder. He falls asleep on the bench. He fell asleep during 2/3 of the trial. And I was like, what the? And I was like, well, this needs to be exposed. And he's like, here's what's going to happen if you go out and make a big deal out of this. Every judge in this county is going to hate you. Many judges in the state will hear about you. Other powerful lawyers are going to dislike you. And they will take it out on your clients. And over time, they will work to discredit you, demonize you, and ultimately try to disbar you. And that was the day I decided I'm never going to limit my legal practice to one jurisdiction. I'm going to live in a place I don't practice, and I'm going to have law licenses in a whole bunch of places. And I'm going to come in like a mercenary and do what I need to do and go home. And the only thing that's priority is my client's interest. And then after that, I'm going to do what I think is just. And hopefully the two align as much as possible and as practicable. But that's the problem with our system. And this decision is deeply problematic on top of that, because they did two things. One of them very sneaky. If being dishonorable and deceptive is grounds for being defrocked and disbarred, that needs to happen to every single one of those judges on the New York Court of Appeals, because what they did was lie. Now, what's nice is it's nice to be a judge. It's sort of like Mel Brooks. It's good to be the king. It's you're the king when you're involved with law licenses as a judge. You get to lie and nobody can sue you for it. And look at what happened by the media. These judges put out a lie that says there was uncontroverted evidence. I'll get to how that's not true. But the media then gets to repeat it because the media is reporting what judges found. The media is now also immune from the lie. So now nobody can be sued for the lie. And this mythology will build up that Rudy Giuliani was found by a court to have deliberately lied about a bunch of things, when Rudy Giuliani has not even had a hearing yet. None of this has been subject to cross-examination. None of this has been subject to discovery. None of this has been subject to depositions. None of this has been subject to a trial. Nothing has been admitted in a manner proper to an actual evidentiary hearing. So when they say there's uncontroverted evidence, there's a bunch of stuff that's controverted, and none of it's really evidence. But judges get away with lying.
So here's my thing. Like, if someone on Twitter, I don't know where I saw the comment, said, you can't lie in court. Suspension justified. And this is what people don't understand, the distinction between being wrong, and that's arguable. But let's just take for granted that Giuliani was wrong, factually incorrect. There's a difference between being factually incorrect and lying. And one involves a state of fact, the other involves a state of intent. And when people say that Giuliani lied, it presupposes his own knowledge of the falsity of the statements, which the falsity itself is disputable. But even if we assume that the statements turned out to be false, to say that he lied to the point where he should be has his license suspended, it really makes a leap in terms of the assumption of his intent and knowledge when he made those statements. Now, I'm looking at the judges, and I'm not going to say they lied, because it doesn't matter, lying or not. When they say that it was uncontrovertible evidence that what Giuliani said was false, therefore his interim suspension is justified, I have a problem even if they believe. I mean, I have a bigger problem if they believe what they're saying, because if they're lying, at the very least, I know they're dishonest. But if they believe what they're saying, they're stupid. And to say that it was uncontroverted is itself factually and demonstrably, at the very least, unverifiable, because it has not been put to that test yet. And the idea that Giuliani said some dead people voted, I'm not. We have cases where there have been people admitting having voted for their deceased parent and regretting it. So to say that it's totally bald-faced lie is incorrect. To the point where it could justify a suspension on the merits is a separate thing, but on an interim basis, that he's such a danger to the practice of law, his limited active practice of law, that they could justify the suspension of his license in the interim. It sets a standard that, like you say, Robert, I don't think it's directed at Giuliani. It's directed at everyone else, and it's directed at people on the political aisle, because we can think of a few examples of attorneys who have done confirmed, demonstrably worse things, who don't seem to have suffered any sanctions, let alone this sanction. I was thinking of Avenatti, but did Avenatti get disbarred after his conviction?
To my knowledge, he's finally been at least suspended. It took forever for them to initiate proceedings. Then the proceedings were stayed. Even well after he was indicted, the California State Bar site now lists him as being inactive or suspended, but it's not clear. I have not found evidence of a final adjudication of his disbarment, put it that way.
Right.
I have a current case in California with a lawyer who ended up paying millions of dollars because of his efforts to defraud my clients that the California State Bar still hasn't taken any action on. So, I mean, it's extraordinary. So the idea that this is the hypocritical application is also another problem. But going further and deeper into this, but in my view is if courts were honest, they would continue a tradition that the Deemsters in the Caribbean jurisdictions do. If you go back and read old Supreme Court cases, U.S. or state Supreme Court cases from the 19th century, you often have to wait to the very bottom to actually get to the ruling because there was this old obligation on courts, still followed by Deemsters in Caribbean jurisdictions in particular, where they have to list, they have a ministerial obligation to identify all the factual and legal arguments by both sides before they get to their own conclusion. Ask yourself, why did courts scratch that tradition? Why did they need to scrap it? Is it because they wanted to lie about what some of the arguments are? Is it because they wanted to create fake and false fact patterns to mislead people into what the patterns is? I tell people right away, never believe a court's rendition of the facts. Never believe a court's rendition of the procedural arguments because I've seen them lie repeatedly. When courts go back to that old tradition, that old common law tradition, then I'll believe what they can later say in the decision. But until then, there's more evidence that these judges lied than Giuliani did.
And case in point, I will not say that the judges lied, but I will say that they selectively misrepresented or got wrong factually the summary of the facts. Michael Flynn, when they kept repeating the having pleaded guilty 2 times before 2 different judges without explaining the context that we got into in some detail, without explaining how the judge had to recuse himself and whether or not the guilty plea in front of a judge who subsequently recused himself for conflict of interest may not be a bona fide, legitimate confession of guilt. Yeah, the judges will summarize the facts in accordance with the conclusion to which they've already come, and good luck on the citizenry to determine what facts were omitted in the summary of the facts. But for the fact that I had been following the Flynn case for months, and I knew when something was missing just by reading the summaries, I wouldn't have known. And I'm probably not more educated, I'm just more informed on that subject than 95% of the people out there. Yeah, when you read the summary of the facts, you're never going to know what was left out of it. In as much as when I edit a video, no one's ever going to know what I didn't put in that video. So it's nuts. But the idea that they are looking at Giuliani and said that what he did poses such a danger that the interim suspension of his license is warranted. Klein Smith, by the way, before I forget, do we know if he's been disbarred, suspended, or sanctioned by the Bar Society for having modified a document, falsified a document that was submitted to the FISA court in order to obtain a renewal of a FISA warrant? Has he been sanctioned that we know of?
I mean, not to my knowledge. And most federal prosecutors who are caught even by courts doing bad acts are never disciplined. A study found that out of state and federal prosecutors that courts had found engaged in deliberate wrongful conduct, out of 2,000 such cases, only 2 had ever faced any form of disciplinary action. So, I mean, that's the nature of it. Now, one added component, or one, before we get into some other Rudy Giuliani problems with this case, just as a factual issue, to give one example, they only identify one factual statement he made to a court that they find problematic. And it's deeply ironic. I'd like to see Nate the lawyer do a follow-up on this, because one of his points about the election lawsuits is that Rudy Giuliani admitted in court that his claims were not fraud claims. Well, guess what the New York court disciplined Rudy for? They said that he said that there were fraud claims and that was what was untrue. So they directly refute an entire media statement and claim it was a lie because he said it was fraud claims. Well, which is it? Was the media lying all along when they said that Rudy said he wasn't pursuing a fraud claims? Or is the New York Court of Appeals lying when they say otherwise? And by the way, as to that point, well, the only point Rudy made in the court proceedings was he said this was by process of a fraudulent process and that these laws came about. But he wasn't bringing a conventional common law fraud claim that required pleading with particularity. Those are 2 totally different things. And the court was New York court, completely misleading about this. That transitions to one of the biggest problems of this, the precedent they're trying to set here, which is they are trying to punish lawyers for the statements they make outside of court that don't specifically relate to a witness or juror or anyone else. So the rules have traditionally been supposed to be interpreted this way, so that you're only prohibited as a lawyer, or you can only be punished by the bar, which is really by the courts. People get confused by that because they hear the bar and they think it's like the American Bar Association. They don't have any power over licensure. This is almost exclusively courts in every state. You might have a bar that's an adjunct to the courts or employed by the courts, but it's all done by the judges. the boys in black robes, the boys and girls in black robes. So and by the way, when they say you can't lie in court, yeah, there's one person who can lie in court, the one that's wearing the black robes. It's got the gavel. They can lie in court. Good luck trying to get a remedy for that. Because guess who gets to discipline them? Guess who gets to investigate them? Guess who they themselves. Isn't that nice? It's good to be the king. They should you just wear a black robe rather than a crown when they're saying that. But the other problem with this is they play games with the nexus of this. So at the beginning of the case, they talk about how we're only looking at what Rudy said in his capacity as a lawyer for Trump. But very quickly, they get away from everything that actually happened in court, because this is critical. No court has found in those court proceedings that Rudy did anything wrong. That Pennsylvania court didn't sanction him at all.
Well, that's what I was going to say, is they're getting into a trial of another trial where even in that original trial, as far as I understood it, he was never sanctioned, reprimanded, or anything. And so they come in now and they are basically assessing the evidence that was adduced before other judges, which is like, I can't think of an example, an analogy, but basically they're two steps removed from what actually happened, sanctioning on the basis of what they think happened in those courts, where he was not even sanctioned for what he did in those courts. Robert, while you take this, I'm going to go get a dog so he stops barking. But
sure.
Carry on that thought, please.
Yeah, so about 90% actually 99% really, of what they complain about are statements Rudy made in the court of public opinion, not the courts of law. And what the ethics rules talk about is you can't make false representations to third parties. What they mean by that third party's provision is they're thinking about, or what they claim to be, is witnesses, jurors. So in those, if you say something outside of court, but it's meant to impact the legal proceeding. Let's say you trick someone into signing something away. You suborn perjury. You extort somebody. Those are things that happen outside of the court proceedings, but they have a nexus to legal proceedings. That's supposed to be the limit. There are no accusations of that against Rudy whatsoever, because this is unique. No court filed this claim with the New York Attorney General, the New York Attorney Grievance Committee. No client filed it. No, to my knowledge, no witness filed it. This is them acting on their own sua sponte to target someone they don't like politically. It's why Dershowitz was so outraged by it right out of the gate. And of course, he disagreed sharply with Rudy on a bunch of political issues, including the election. So that's one of the big core problems, is their attempt to expand the rules to say, as a lawyer, we now get to govern everything you say. And initially, they try to limit it by saying, we're only looking at it when you're doing it in your capacity as a lawyer, even though they're defining that to mean any public statement you make at all concerning any client or any case. But then the end of the case reveals they're not even limiting it to that, because they say we have to immediately suspend him because he keeps talking about this issue, but he's no longer doing it in a legal capacity. There is no pending case. There is no existing client. Their goal is to basically punish speech they don't like. And to use their licensure control to do so, and to set a precedent with Rudy, because if they can do it to the former U.S. attorney and mayor of New York, by golly, they can do it to you. And so people out there that think that this was an okay case really need to study what the impact is of that last part of the ruling that says we can say he's an imminent threat to the practice of law based on no practice of law at all, but based on his political public statements that we don't like. It's
actually shocking, and I hope everyone appreciates that distinction in this. And I will not speak from my own experience, because unless some of these things become public, they will not be public. But I can speak from someone's experience who has made it public. Nick Rekieta, who noticed that he'd never gotten an ethics complaint as an attorney, but the second he started discussing certain things online, that's when you start getting ethics complaint from people who don't like what you're saying. And they say, it's a lawyer making these public statements, expressing First Amendment rights in the United States. I don't like what that lawyer's saying. So what am I going to do? I'll go to their bar society and try to get them where they think it hurts. And it's an amazing thing where the law society is sort of forced with this dilemma of having to even address discussing what someone who happens to be a lawyer is saying in non-law cases in which they're not involved. And basically, it's tantamount to trying to punish someone who happens to be a member of a professional order for statements they make on a totally unrelated basis in the public sphere that are otherwise First Amendment protected. And that is effectively the distinction that you're drawing here with Giuliani. Is the major one, is that they're going after him, and they said it in the decision. Some things he said in court and other things he said in public But he's allowed having an opinion, even if he is a lawyer representing someone in a case, and all the more so when he's no longer representing someone in a case, to make certain public statements. And they're trying to punish him for that, and they have effectively punished him for that. And if anybody thinks that that's okay for Giuliani, wait until it comes to another subject where you might have said something publicly and been a member of a professional order, I don't know, on other hot issues of the day, where someone says, I didn't like your position on the trans athletes debate. I'm going to file a complaint with your law society. And even though you didn't make those statements in the context of a law file, you can still be suspended. It's just the chilling effect on freedom of speech. And this is how they weaponize it against professionals.
Absolutely. And what the law is always about, it's one area where I agree with Michael Malice in his book. He republishes a law review or a law professor's argument about the law, that there is an objective law, that our law is really comes down to one simple decision. And this is a good bridge to our next case, which is who decides. The problem with people feeling comfortable with this about Rudy Giuliani is they're forgetting who's going to decide what's true and false in what you say in the court of public opinion. Do you want, and that's what you're doing. You're giving a bunch of judges the power to determine whether your speech was true or not true. And good luck with how that turns out, because it's almost never been used to benefit ordinary people or dissident causes.
All right. And by the way, let me see what he said this here. Sorry, got stuck. Nice to have the lawyer dog make a cameo. I gave him the most thorough bath on earth last night, because 3 days camping with the dog, it was the most glorious, liberating thing for the dog, but he was rolling in everything from the fine silt of the St. Lawrence River to, I think it was raccoon poop, but we'll see. Okay, Robert, what do we transition to now?